Good morning, students. How are you? Hope all are fine. The coronavirus, so the problem not yet get over. So we don't know. So when the schools will reopen. So hope soon the schools will reopen. So before that, so we will continue with the online class itself. So take your book. So before that, so say your prayer. தேங்க்யூ. நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். ஸோ டேக் யுவர் சோசியல் சயின்ஸ் புக் அண்ட் டேக் பேஜ் நம்பர் 259. So today also we will continue with civics. So the state government. So in our previous classes we have discussed about the union government, that is the central government. So the three organs of the central government. Then about the president, prime minister, then the council of ministers. Then also we discussed about the parliament, the two houses of the parliament, and also finally about the judiciary, that is the Supreme Court of India. So this is for the whole country, the whole India. But you know India is divided into states and union territories. So and power was divided. So our constitution has arranged a federal form of government, that is power was distributed between central and state. So you learn about central government. I hope you have no doubt in that lesson. So in this lesson, so we will learn about the state government. So the structure of the state government. So structure of the state government is as like that of the center only. That is state government also consists of three branches: executive, legislative, judiciary. So we will discuss in this topic in case of in relation with the state government. Okay, ma? So learning objectives. So what are you going to learn? So students acquire knowledge about the structure of the state government. So students acquire knowledge about the structure of the state government. So already you will know about the central government. So now from this lesson you will learn about the structure of the state government. Then to understand the powers and functions of the governor, chief minister and the speaker. So speaker means the person who presides over the meeting of the legislative assembly. So in case of Lok Sabha it was also speaker. So already you learn about the Lok Sabha speaker. Here you learn about the speaker of the state assembly, state legislative assembly. So understand the powers and functions of the governor, chief ministers and speaker. Then to know about the state legislature. So already in previous lesson you learned about the parliament, the two houses of the parliament, Lok Sabha and Rajya Sabha. So here you will learn about the state legislature. So most of the state have only one legislator, that is legislative assembly, but some state have two houses. So most of the state legislature have only one house, that is legislative assembly, but some of the state so they have two houses, so legislative assembly and legislative council. Then so student understand the functioning of the judicial system in the state. So in case of state it was high court. So Supreme Court is for whole India, but high court, so for every state there is a high court. So for Tamil Nadu it was in Madras. Okay, so in learning objectives, so what are you going to learn from this lesson? So students acquire knowledge about the structure of the state government. Then to understand the powers and functions of the governor, chief ministers and speaker. Then to know about the state legislature. Then finally about understand the functioning of the judicial system in the state. So in this video you will learn about governor, so the executive head. So the executive power you will learn about governor. So how was he appointed, what are the qualifications, then what are the powers and functions of the governor. Then finally about some special rights for the governor. So you will learn in this class. So introduction. So the Constitution of India envisages. So envisage means so to imagine what will happen in the future. So envisage, that is so our Constitution of India. So our Constitution so imagine for a federal government having separate system of administration for the union and the state. Our Constitution of India so arranged for a federal government. So wanted a federal type of government, that is so power should be, that is administrative power should be distributed between union and the state. So now there are 28 states and 9 union territories. You know, so recently, so Jammu and Kashmir was divided as union territory. Yeah, so Ladakh and Kashmir union territory. Yeah. So 29 states now become 28 states and 9 union territory and one national capital territory known as Delhi in India. Yeah, so our constitution so arranged for a federal form of government. Yeah, so wanted a federal form of government, so which you have a separate system of administration for the union and the state. So there are now 28 states and 9 union territories and one national capital territory known as Delhi. So the constitution contains provisions for the governance of the both union and the state. So our constitution so contains the articles, so contains the provisions, so that is the act of supplying somebody with something. So the rules and regulations for the governance of both the union and the state. So it lays down a uniform structure for the state government in part 6 of the constitution from article 152 to 237. So for all the state, so there is a uniform structure of government. So which was mentioned in part 6 of the constitution. So from article 152 to 237, so which is applicable to all the state. So the structure of the state government as formed in the center consists of 3 branches. So the structure of the state government is as like that of the central government, that is consists of 3 organs. So what are they? Executive, legislature, then judiciary. So our constitution so wanted a federal form of government, so that so the power was, so the administrative power was divided between the union and the state. So now there are 28 state and 9 union territories and one national capital territory. So our constitution so contains the provisions for the governance of both the union and the state. So it lays down a uniform structure for the state government in part 6 of the constitution from article 152 to 237, so which is applicable to all the state. So the structure of the state government is as like that of the central government, that is consists of 3 branches, 3 organs. So legislative, executive, then judiciary. So then executive, so part of the government responsible for putting laws into effect. So executive part means so the part of a government responsible for putting laws into effect. So first the governor. So the governor is the constitutional head of the state executive. So as for the center it was president. For the state it was governor. So the constitutional head of the union executive was president. Same way the constitutional head of the state executive was the governor. So generally there is a separate governor in each state, but if the situation warrants, so generally there is a separate governor for each state. But if the situation arises means the same person may be appointed as the governor for 2 or more state. So generally there is a separate governor for each state. Suppose if the situation arises means so a single person can be appointed as the governor for 2 or more state. So article 154 vests the executive power of the state in the governor. So article 154 vest so says, that is vest means to give somebody the legal right or power to do something. So article 154 so gave some legal right, so gave the power, that is gave the executive power of the state is with the governor. So governor is the constitutional head of the state executive. So there is a separate governor for each state. But if situation arises means a single person may be appointed as a governor for 2 or more state. So the executive power of the governor was mentioned in article 154. Appointment. So who appoint the governor of a state? The governor of a state shall be appointed by the president. His usual term of office is 5 years. So the governor was appointed by the president of India, and his term of office is 5 years, but he hold office during the pleasure of the president. So usual term of office is 5 years, but he can hold the office during the pleasure of the president. That means president can ask the governor to resign before the expiry term, or he may ask him to continue even after the expiry of his term. So generally the governor does not belong to the state where he is appointed. So the governor does not belong to the state where he is appointed. Our governor, so Banwarilal Purohit, so he is not from Tamil Nadu. So he can also be transferred from one state to another by the president. So the governor can be transferred from one state to another by the president. he can also resign anytime by addressing his resignation to the president. So the governor also resign anytime by addressing his resignation to the president. So the governor of a state shall be appointed by the president. Then his usual term of office is 5 years, but he can hold his office during the pleasure of the president. So generally, so the governor does not belong to the state where he is appointed. So the governor does not belong to the state where he is appointed. So he can also be transferred from one state to another state by the president. Then he can also resign anytime by addressing his resignation to the president. The legislature of a state or a high court has no role in the removal of a governor. So can you remember? So the president can be removed by the parliament by the process of impeachment. So the same procedure was not in case of governor. So the legislature of a state or high court has no role in the removal of a governor. Only the president has the power. So he can appoint the governor, he can remove the governor. A person may be appointed as a governor for any number of terms. Yes, a person can be appointed as a governor for any number of terms. So two conventions have been set up in the matter of appointing a person as a governor of a state. So two conventions. So convention means a traditional way of doing something. So some two event. So two things. So traditionally was considered. So what was they? He should not be a resident of the state concerned. So already we saw. So the governor does not belong to the state where he is appointed. So first one. Then before appointing him as the governor, so the president have to consult with the state government. So the state government concerned is consulted and its views are sought regarding the proposed choice. So the state government is consulted before appointing a person as the governor. So according to Article 158 3A, the same person is appointed as the governor of two or more states. The emoluments. So emolument means money paid to somebody for work they have done. And allowances payable to the governor shall be allocated among the state in such proportion as the president may order determine. So according to Article 158 3A, so when a same person is appointed for governor for two or more state means, then the emoluments, that is the salary and allowance, so paid to him can be shared by the respective states, and the proportion, the shared proportion was determined by the president through an order. Okay, so in case of the governor, so he can't be removed. So there was no role by the state legislature or high court. So a person may be appointed as a governor for any number of terms. So here, so two important things have been noted. So one is, so he should not be a resident of the state concerned, and the state government opinion is consulted. So according to Article 158 3A, so the same person is appointed as the governor of two or more state. The emoluments and the allowances payable to the governor shall be allocated among the states in such proportion as the president may by order determine. So his salary and allowances payable was determined by the president. So that should be shared by the respective states. So qualification. So what are the qualifications to be appointed as the governor of a state? So Article 157 and 158 of the Constitution of India specifies eligibility requirements for the post of governor. So Article 157 and Article 158 so says about the requirements, so eligibility requirements for the post of governor. So what are they? So first, he should be a citizen of India. Then he should have completed 35 years of age. So these two things are common for the president also. So to become a president, so he should be a citizen of India. Then he must have completed 35 years of age. Then he should not be a member of parliament or of any state legislature. So he should not be a member of parliament. That is, he should not be MP or an MLA of, that is not a member of any state legislature. If he is a member of any legislature, he automatically vacates his seat on assuming the office. So suppose if he is a member of any legislature means, then he automatically vacates his seat on assuming the office. So when he assumed the office of governor means, then his seat in the state legislature became vacant. Then he should not hold any other profitable occupation. So he should not hold any other profitable occupation. So to become the governor of a state, so the eligibility requirements were mentioned in Article 157 and Article 158. So they are, he should be a citizen of India, then he must have completed 35 years of age, then he should not be a member of parliament or any state legislator. Suppose if he is a member of any legislator means, then he automatically vacates his seat on assuming the office. Then he should not hold any other profitable occupation. So these are the qualifications so required for the appointment of governor. So powers and functions of the governor. So the governor is the head of the state executive. So the governor is the head of the state executive and he has enormous power. He have lot of powers. See, in the excess of functions and powers, the governor, except in certain cases, is to be guided by the aid and advice of the council of ministers headed by the chief minister. As per Article 163, so the governor so have to work. So the governor had to guided by the advice of the council of ministers. So the governor, except in certain cases, is to be guided by the aid and advice of the council of ministers headed by the chief minister. So the governor is the head of the state executive and he has enormous power. So in the excess of functions and powers, the governor, except in some cases, he has to be guided by the aid and advice of the council of ministers headed by the chief minister. That means he have to consult with the chief minister, so who guide the council of ministers. So with the help of the council of ministers headed by chief minister, so the governor have to perform his functions. Okay, so his powers can be studied under the following headings. That is the executive power, legislative power, financial power, judicial power, discretionary power, then emergency power. So the powers of the governor can be studied under following heading: executive power, legislative power, financial power, judicial power, discretionary power, then emergency power. So we will discuss one by one. Executive power. So who are all appointed by the governor of a state? So he appoints the leader of the majority party in the state legislative assembly as the chief minister of the state. So he appoints the leader of the majority party in the state legislative assembly as the chief minister of the state. So how Edappadi K. Palanichami became the chief minister of Tamil Nadu. So initially at the time of election, so during the time of election 2016, so we people so choose Jayalalitha as the leader. So we choose her as the MLA. Their party leader choose her as the leader of the state legislative assembly. But after his death, so the majority party ADMK so choose the leader as their chief minister. So choose Edappadi as their leader. So he became the chief minister. So hope you understand from that. So the governor appoints the leader of the majority party in the state legislative assembly as the chief minister of the state. Also he appoints the other members of the council of ministers on the recommendation of the chief minister. So he appoints other ministers, so other members as the ministers on the recommendation of the chief minister. He appoints the chairman and members of the state public service commission. So he appoints the chairman and members of the state public service commission. Then he appoints the state election commissioner and determines his conditions of service and tenure of office. That is the period of office, term of office. So the governor appoints the state election commissioner and determines his condition of service and tenure of office. Then he acts as the chancellor of universities in the state. So he acts as the chancellor of universities in the state, and also he appoints the vice chancellor of universities in the state. So in Tamil Nadu we have a lot of universities. So Madras University, then Bharat University, Pondicherry University, Agriculture University, like that. So for all the universities, so he is the head. So he is the chancellor. So he appoints the vice chancellor of universities in the state. Then he directly rules a state when there is in the imposition of president rule in the state. So the governor can rule a state directly if the president rule is imposed. So executive power. So he only appoints the chief minister. So who was appointed the chief minister? the person who get majority support in the state legislative assembly. Then he appoints the council of ministers on the advice of the chief minister. Then he appoints the chairman and the members of the state public service commission. Then he appoints the state election commissioner and determines his condition of service and tenure of office. Then he was the chancellor of universities of the state, and he appoints the vice chancellor of the universities of the state. Then he directly rules a state when there is the imposition of president rules in the state. Then the legislative power. So the governor is an integral part of the state legislature. So in parliament, so the president is the integral part of the parliament. So the parliament means it consists of Lok Sabha, Rajya Sabha, and also the president. In case of state legislature, so the governor is an integral part, but he is not a member in the either house of the legislature. So the governor is an integral part, but he is not a member in the either house of the legislature. In this capacity, he enjoys the following legislative power and functions. So in this category, so he enjoys following powers. So first, he has the right to summon. So summon means arrange an official meeting. Prorogue, that is, so stop or discontinue a session. So he has the right to arrange a meeting or discontinue the state legislature meeting and dissolve the state legislative assembly. So the governor has the right to summon, prorogue the state legislature and dissolve the state legislative assembly. Then he can address the state legislature at the commencement of the first session, after each general election, and the first session of each year. So can you remember that in case of parliament it was president? So president gave the speech. So he can address. So the president address the parliament. In case of the state legislature, so the governor address at the commencement of the first session after each general election and the first session of each year. Then he can send message to the houses of the state legislature relating to a bill pending in the legislature. So he can send message to the houses of the state legislature relating to a bill pending in the legislature. So bill, so after passing it will become an act. Then he can appoint any member of the legislative assembly to preside over its proceedings when the office of both the speaker and the deputy speaker fall vacant. So if there is no speaker and deputy speaker, so if they were absent means, then the governor can appoint any member from the legislative assembly to preside over its meeting, so to carry out the meeting. Then he nominate one member of the state legislative assembly from the Anglo-Indian community. So in case of parliament, so two Anglo-Indian community members were nominated to the Lok Sabha. So in the case of legislative assembly, one Anglo-Indian community member can be nominated by the governor. Then if there is legislative council, so some of the state in India have legislative council. So in Tamil Nadu we don't have legislative council, but some other states, so like Andhra, so Telangana, so they have legislative council. So in that, so he nominate 1/6 of the members of the state legislative council from amongst the persons having special knowledge or practical experience in literature, science, art, cooperative movement and social service. So just to compare with the Rajya Sabha. So 12 members were nominated by the president. So same in case of legislative council, 1/6 of the members of the legislative council can be appointed by the governor, so who have special knowledge in field like literature, science, art, cooperative movement and social service. So every bill passed by the state legislature will become law only after his signature. So every bill passed by the state legislature will become law, become an act only after his signature. But when a bill is sent to the governor after it is passed by the legislature, he has the option to give his assent. Assent means official signature or accept, officially accepting the bill or withhold his assent to the bill or return the bill for the reconsideration of the legislator. So every bill passed by the state legislator will become an act or law only after his signature. So so every bill passed by the parliament will become an act after getting signature from the president. So same way in case of state legislator. Yeah. So here the governor signature is very important. Yeah. So when a bill is sent to the governor means, so he have three choices. So first one is he has give his assent to the bill, then or he can withhold his assent to the bill, or he can return the bill to the legislator for reconsideration. Then he can promulgate ordinance when the state legislator is not in session under Article 213. So promulgate means to announce a new law or system officially or publicly. So promulgate means to announce a new law. So the governor has the power to announce a new law. So ordinance means an order or a rule made by a government or somebody in a position of authority. So that means, so the governor has the power to announce, has the power to order, so made a rule, so made a new law. So when the state legislator is not in session under Article 213, so under Article 213, the governor can declare a new law. But this ordinance must be approved by the legislator within 6 months. So when the state legislator, so again formed means, so the legislator have to approve this law, so this ordinance within 6 months. So he can also withdraw an ordinance at any time. Then he has to lay the annual reports of the State Finance Commission, the State Public Service Commission, and the Comptroller and Auditor General relating to the accounts of the state before the state legislator. So he has to lay the annual reports of the State Finance Commission, the State Public Service Commission, and Comptroller Auditor General relating to the accounts of the state. So Comptroller Auditor General is for the whole country. So he was appointed by the president. So he submits the accounts to the governor. So the governor lays the report to the assembly, so before the state legislator. So the governor has the power to lay the annual reports of the State Finance Commission, the State Public Service Commission, and the Comptroller and Auditor General. So in case of legislative power, so every act of the assembly was with the governor. So the governor role is very important in case of the state legislative assembly. So every bill passed by the legislator can become act only after getting his assent. Okay. The financial power. So the constitution confers on the governor the duty to get prepared and to introduce in the state legislator the annual budget or annual financial statement and also the supplementary budget if necessary. So the constitution confers on the governor. So it was the governor's duty, so to get prepared and introduce it to the state legislator the annual budget and also the supplementary budget if necessary. So the annual budget, that is the state financial statement of the financial year, was submitted to the legislative assembly by the finance minister in the name of governor. Okay, so money bills can be introduced in the legislative assembly only with his prior recommendation. So money bill can be introduced in the assembly only with his prior recommendation. Then he can make advances out of the state contingency fund to meet any unforeseen expenditure. So if there is any unforeseen expenditure, so if there is any unexpected expenditure means, then the governor role is very important. So he can make advances out of the state contingency fund. So contingency means, so maybe emergency. So the fund can be taken. So the contingency, the amount from the contingency fund can be taken only after getting permission from the governor. Then he constitutes a finance commission after every 5 years to review the financial position of the panchayat and the municipalities. So he constitutes a finance commission for every 5 years, so to review the financial position of the panchayat and the municipalities. So in case of financial power, so the financial statement, that is the annual budget, was presented in the assembly by the finance minister, so only in the name of the governor. So money bill can be introduced only after getting his prior recommendation. Then so for using the contingency fund, his recommendation, so his role is very important. Then he constitutes a finance commission after every 5 years, so in order to review the financial position of the panchayat and the municipalities. Then judicial power. So we have discussed the executive power, legislative power, then financial power, then the judicial power. So he appoints the attorney general of the state. Yeah, so there is attorney general for India, so he was appointed by the president. So in case of the attorney general of the state, so was appointed by the governor. So he make appointment, postings and promotions of the district judges in the consultation with the state high court. So there is court for every district. So he makes appointment, postings and promotion of the district judges in consultation with the state high court. Then the chief justice of the high court in the state is appointed by the president. So the chief justice of the Supreme Court and the high court was appointed by the president. But the chief justice of the high court in the state is appointed by the president in consultation with the governor. So the president so consult with the governor before appointing chief justice of the high court. Then he can pardon, commute or reprieve punishment on receipt of appeals for mercy except death sentence. So except death sentence, he can pardon, commute or reprieve punishment. So what do you mean by pardon, commute, then reprieve? So can you remember? So while studying about the judicial power of the president, I have told you. So pardon, commute or reprieve. So pardon means an official decision not to punish somebody for a crime. So pardon means an official decision not to punish somebody for a crime. So reprieve means so stay of the execution. So stay of the punishment for a temporary period. Then respite. So respite means award less sentence due to some special fact such as physical disabilities. Okay, so pardon, commute or reprieve. So pardon means so official decision not to punish somebody for a crime. So commute or reprieve means so stay of execution for a temporary period. Okay, so that is not for death sentence. Okay, so these are the judicial power. So he appoints the attorney general, then he makes appointments, postings and promotions of the district judges in consultation with the state high court. Then the chief justice of the high court in the state is appointed by the president in consultation with him. Then finally he can pardon, commute or reprieve punishment on receipt of appeals, that is getting appeal from the particular person so who got the punishment. So for mercy except death sentence. So death sentence, so it can be cancelled or it can be executed. So only, that is, it can be withheld only by the president. Okay, then the discretionary power. So discretionary power means so decided according to the judgment of a person in authority about what is necessary in each particular situation, not decided by rules. So discretionary power means so decided according to the judgment of a person in authority. So decided according to the, so this power, so the situation decided according to the judgment of a person in authority about what is necessary in each particular situation, not decided by rules. So the governor can reserve a bill for the consideration of the president. So if the state legislator, so if they send a bill to the governor means the governor can give his assent, or sometimes he can reserve a bill for the consideration of the president. Then he can call the leader of any party to form ministry in the state when there is no clear-cut majority to any party in the legislative assembly after the general election. So after the general election, if there is no party get the official majority means then he can call the leader of the any party to form ministry in the state. So if there is no party so get the required majority means then he can call any leader so who have more number of seats in the general elections in the assembly after the general elections to form the government. Then he can dismiss the council of ministers when it is unable to prove the confidence of the legislative assembly. So he can dismiss the council of ministers when they were unable to prove their confidence in the legislative assembly. So first he can reserve a bill for the consideration of the president. Then he can call the leader of any party to form the government when there is no clear-cut majority after the general election to the assembly. Then he can dismiss the council of ministers when it is unable to prove the confidence of the legislative assembly. Yeah. So in case of assembly, the council of ministers, so they were responsible. Okay. Then emergency power. So if the governor satisfies that the government of the state is not carried in accordance with the provisions of the constitution, he may under article 356 recommend to the president to impose president rule in the state. So if the governor thought so that the state government is not running as per the constitution, as per the articles mentioned in the constitution, then he may under article 356 recommend to the president to impose the president rule in that state. So as soon as the president rule is imposed, the administration of the state is carried on by the governor as the representative of the president. So in case of emergency power, so if the state government is not running as per the provisions of the constitution, then the governor, so under article 356, recommend the president to impose president rule. So during that time, so the governor act as the representative of the president. So the administrative power is now with the governor directly. Okay, ma? Then the privileges of the governor, that is the special rights for the governor. So article 361 part 1 provides for the following privileges for the governor. So the governor of a state is not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those power and duties. So that means, so the governor of a state is not answerable to any court for the duties so that he had performed or the functions that he is going to perform. So the duty already he had done, or the duty he is going to done, he is going to do. So he is not answerable to any court. So no process for the arrest or imprisonment of the governor of a state shall issue from any court during his term of office. So during his term of office, so he should not be arrested. So there is no provision. So there is no process for the arrest or imprisonment of the governor of a state. So these are the special privileges. So first, he is not answerable to any court, so for exercising his duty. Then second one, so there is no process for the arrest or imprisonment of the governor of a state. Okay, students. So in this class we have discussed about the executive, so the governor. So if you have any doubt in this topic, so please contact me. So today's textbook reading. So take page number 260. Read that paragraph, appointment. So 3 paragraph is there, read it fully. So stand up and read it loudly. Then homework. So take page number 268. 6th Roman letter, answer in detail. So second detail, describe the legislative powers of the governor. So take page number 260. So legislative power heading is there, no? So leave that first paragraph. So there is 9 point. So just read 6 points now. So you have to read 6 points. Okay, ma? So you have to read 9 points, but now just read 6 points alone. And write it in your homework note. Okay, so do it properly. So if you have any doubt in this topic, so please contact me. So after listening this video, so compare it with the president also. So the powers and functions of the president also. So what was the difference between them? So try to understand. Okay, students. So thank you. Have a nice day.